Are you about to go through a divorce and wondering if everything will just be divided 50-50 by the judge? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm talking about how assets are divided in Connecticut divorce court. People often assume that in a divorce, the judge will just look at all the assets and split things down the middle to divide things equally, and that is not the case. Judges in Connecticut are authorized to divide assets based on what they feel is fair and equitable, which is different than equal. Equitable is not the same thing as equal. In determining how assets are divided, the courts are authorized to consider a number of factors in making that determination, and those factors are laid out in Connecticut General Statute Section 46B-81. Now, the court can consider the length of the marriage, the causes for the breakdown of the marriage, the age, health, station, occupation, amount and sources of income, earning capacity, vocational skills, education, employability, estate, liabilities, and needs of each of the parties, and the opportunity for future acquisition of capital, assets, and income. The court shall also consider the contribution of each of the parties in the acquisition, preservation, or appreciation and value of their respective estates. So basically, judges can consider all of these factors and essentially do what they feel is fair and equitable. So let's talk about what that looks like in practice. Oftentimes, judges will simply say that everything accumulated during the marriage is to be divided 50-50, and everything that each of the parties had prior to the marriage is kept separate. And that is especially true in shorter-term marriages, say marriages of 15 years or less, where judges will divide out those premarital assets. It's less true in longer-term marriages of maybe 15 years or more, and that 15 years is not a set number. It's really flexible depending on the judge. In those longer term marriages, the judges are less likely to look at the premarital assets, and they're more likely to just divide everything 50-50. So it really depends on the length of the marriage, the assets that each party had coming into the marriage, etc. And there are also some other special circumstances in which assets accumulated during the marriage are not necessarily divided 50-50. Those are inheritance, for example. Inheritance is not an asset that was accumulated based on the work of the parties, which is generally divided 50-50. Inheritance is kind of kept in a separate category where it's really sort of a gift based on the fact that their parent gave them or some other relative gave them that asset. And that can often be kept separate and is not divided equally between the parties. And that's especially true if the inherited asset is kept in a separate account, or maybe it's a piece of property that only the party who received the property is on the title. So generally, those inherited assets are more likely to be kept separate. Another example of assets not necessarily being divided equally is if there is a situation of waste of assets. So let's say one party had a gambling addiction or a drug addiction, or they were unreasonably spending assets after the breakdown of the marriage, or maybe they had an extramarital affair and they spent a bunch of money on that relationship. In that situation, the assets that were depleted based on the inappropriate behavior of that party is likely to come out of the offending party's 50% share, so that the non-offending party will receive a higher percentage of the assets that would otherwise be divided. Now, ultimately, judges are human beings, and not every judge is going to treat a situation the same. Some may be more likely to divide assets 50-50 and not keep premarital assets separate, for example. Or other judges may be more likely to keep premarital assets separate, even in very long-term marriages. So it's really hard to predict exactly what a judge is going to do, which is why it is always best to try to settle your case and resolve it outside of a judge making a decision, because you maintain that level of control to have a somewhat predictable result. So it's always best to try to settle your case, even if it means you're giving up a little bit more than you feel that you should. So those are the basics on how assets are divided in Connecticut divorce court. As usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a divorce or other family law case here in Connecticut, we would invite you to contact our office as well.